So if we accept that the law leads to social control, in other words, there are series and structures of rules and laws that are created, and there's some sort of habit of those rules being followed, and as a result, order is maintained in our society. If we accept that that exists, we can, I guess, trace that backwards to try and understand the question, well, why? Why is it that these things are followed, and how did they come to be? And to answer that, there's really three aspects that need to be discussed and analysed in more depth. Validity, in other words, looking at whether an actual law is a law and is it valid. Authority, in other words, does a particular lawmaker or agent have the power to exert power over others? And sovereignty. Sovereignty is really to do with the power of the state and whether it is recognised as legitimate in unto itself. And we'll look at each of these three in more depth shortly. So the first of these that we'll examine is the underlying validity of laws. Because really any given system of rules are really only effective if they are actually followed. In general though, rules are only followed if the people to whom those rules apply actually think there is some form of legitimacy and validity in unto themselves. Now, some people do, of course, disobey rules because they think they can get away with it, but that's really a different set of questions. So here we're trying to look at what actually gives the law its legitimacy. And not just individual laws, but also the underlying institutions. In exploring this idea of the legitimacy of law, we have to concern ourselves with working out what are the powers and what are the limits of those powers and these institutions, and really what's the nature and extent of what they can do and they can't do. So for example, when you as an undergraduate student are dealing with the staff, it's apparent from your perspective that the lecturers, for example, have the power to, say, set the due date for the assessment. But, however, the staff would not have the power, for example, to change or modify the underlying building. We can't set the height of the building or make structural changes to the environment that we're in. It's outside the scope of what our particular authority would be in that situation. Now, when thinking about authority, it may be helpful to just examine this as a thought experiment. When you're walking down the street and you see a person wearing a police officer's outfit, an image in your mind is conjured of the fact that, hey, this person is a police officer. And the scope of the authority of police officers is to stop, question people, ask for particulars, and to arrest when they suspect that a particular person is doing something unlawful. Now, when seeing a person wearing that uniform in the context of, say, a fancy dress party, if the person wearing that uniform is surrounded by 30 other heavily intoxicated teens dressed up in all sorts of other sort of uniforms, that thought may not immediately come into the mind of the person. Now, again, as a thought experiment, think to yourself, what is the difference between a police officer wearing a police uniform and a person in a fancy dress costume dressed up as a police officer? What's the actual underlying difference between these two things, assuming it's the same person wearing the exact same uniform in the exact same manner? And the only actual underlying difference is really to do with the source of their power. In other words, one of the two has been validly appointed by the government of the day through following a series of rules. They've had to go to some form of police academy. They've had to have some form of background check. They've had to have a huge amount of training. They have, underneath it all, an aspect of legitimacy that a person wearing the police officer's uniform doesn't. But from the outside, there is no straightforward mechanism of telling. Now, when a police officer actually does question you, and as you're walking down the street, it may be helpful to also think, well, what is the actual extent of what that person's power to do things to you is? As I mentioned, police officers in the state of Queensland do have the power to stop an individual, to ask for particulars, and it's an offence to refuse to give your name and your address. However, assuming that there's not a crime that's in progress or might reasonably be in progress, the police officers don't have the power to arbitrarily arrest people. How do we know this? Well, because it's governed by law. The scope of the authority that's given to the police in the state is governed by a series of statutes. We, as citizens, recognise the underlying legitimacy of that structure, not necessarily of the person standing in front of us, but certainly of the underlying legislation and the legitimacy of Parliament to pass those laws. And really that's the heart of this trying to come to grips with what authority means. People, agents and institutions are given powers through the legitimate will of the sovereign to do things, but they're not given unlimited power and discretion to do whatever they like. So when the police officer is standing in front of us, we know that that person, assuming that she or he is actually a police officer and not a person merely impersonating one, has authority to do things, often detrimental things, and infringe on our rights to some extent. And whether or not we agree or disagree with that being a good thing or a bad thing, in other words, this aspect of authority and legitimacy is quite independent of any underlying ethical or moral considerations we might have. What is accepted is that that officer draws legitimacy and her or his authority from some underlying statute. And we also accept that that statute has been legitimately passed through Parliament. Now, what we'll look at this stage is this third aspect, which is really to do with the idea of sovereignty. The idea that citizens essentially obey this great centralized power, and we accept that that power is given to this entity to govern and to also interact with other states. And by states I mean both states within the Federation of Australia and nation states. So in a simpler sense, sovereignty is the source of absolute power vested in the state. It's the supreme authority that citizens give to that entity or institution to govern, usually within a specified territory. When discussing sovereignty, it may be helpful to draw reference to the English philosopher Thomas Hobbes. Now, Hobbes wrote a very famous treatise on sovereignty called The Leviathan, and he was writing this throughout the English Civil War. Now, what Hobbes's theorem is that individuals, people, citizens, if given the opportunity to, run amok, will. And so, in order to create a decent society, or a society where we're not going to be running around killing each other, we all have to cede our personal sovereignty to one all-powerful entity or institution. Now, in Hobbes's time, he believed that that ought to be a monarchy, because, look, yeah, sure, it's arbitrary, but at least it's easy for people to identify who the person is. And Hobbes' theorem is actually really quite simple, that if individuals are allowed to exercise, some form of personal sovereignty, and he has a great line for this. He says, each of us will play the cards in our own hands as if they were trumps. In other words, what I think should be in society, what I think are good things to have or to be, are going to be different from what you think. And if we're all given the opportunity to try and express that life will be nasty, short, and brutish, because it becomes a war of all against all. So for Hobbes, the only solution is to have an all-powerful sovereign. The sovereign has complete dominance over everyone in society. We all obey, and this is the only starting point for maintaining any form of social order. So sovereignty then is this exclusive right to have supreme authority in a particular territory. The sovereign is given the power to make laws, the sovereign alone to make laws. Now, of course, in our society we think, well, it's not just the state that makes laws, other people can make laws as well. The councils, various sort of subordinate bodies can make laws, and the courts also make laws as well to some extent. And yes, I guess that's strictly correct, but from, this Hobbesian perspective, all of this flows from the absolute power of the crown to bestow authority on these other entities to actually go about making these laws. The crown has absolute power and absolute, the absolute right to govern, exclusive of all others, all other parties, for a particular territory. And so when we're thinking about sovereignty, there's both this internal aspect, in other words, that institution is the absolute source of power within the territory, but there's also an external dimension to sovereignty as well. Now, this concept of the nation state is actually relatively recent. Going back sort of 400 or 500 years ago, there was no real concept of the nation as what we would consider to be a sovereign. It was really fundamentally a might is right aspect of things. And I'm not to say that it's not that now, but after a series of wars in Europe, if you care to go and research it, there have been a lot of wars in Europe over the last 2,000 or 3,000 years. But there was one particular series of wars involving many entities inside Europe that concluded with a series of treaties in the mid-1600s. And we talk about one in particular, this Treaty of Westphalia, as really the starting point for our modern concept of international sovereignty. So the important thing to note about the Treaty of Westphalia, and largely what's been written about it since that particular time. I mean, the treaty itself was a little bit light on detail, a bit like the Magna Carta, as I'll talk about a bit later. But the really fundamental thing that came from that is that all of the states and entities that were signatories to that recognized the sovereignty of others. That's not to say they liked each other. That's not to say that they wouldn't, if given the opportunity, invade and conquer each other. It It's the starting point for recognizing the sovereignty of others over their territory. And really, it was also a starting point in terms of trying to come to some form of coexistence. And partially that was by laying down the grounds for the rules of war in terms of how states resolve conflict. And so when you hear the phrase Westphalian sovereignty, it's really that idea that states recognize other states, and I think most importantly, there is no higher power. There is no appealing to some form of supranational entity with the power to govern or resolve disputes between nations. The state, the nation state, is the highest form of government. So when trying to determine whether or not a particular sovereign entity is legitimate or not, we can return to the analogy to do with authority and the police officer. What makes a police officer, a person wearing a police officer's uniform, what gives that person the authority to do things to the citizen, to curtail your rights somehow, that a person merely dressed in a police officer's uniform? And the answer is the underlying law and the legitimacy and validity of the laws giving authority to that particular person and not to the other. So when we think of the sovereignty of states, what gives them their legitimacy? And the answer really lies in what we call sovereignty stories. Now, these sovereignty stories, which by the way can be a very interesting area of history to look at, they can develop in all sorts of ways. So for example, some form of customary authority. Look, we can have a customary system where traditions that have been in place for a long time and have been upheld by generation after generation after generation, even where we don't know what the original source is, often in oral cultures and societies where the original making of these things is lost and it's modified over time. But that customary authority is what's recognized in terms of the underlying sovereignty of the place. Alternatively, there may be some form of supernatural authority. So if we think of the pharaohs of ancient Egypt. Now, Egypt, unlike all of the other sort of ancient cultures, where in most other cultures the priest class and the ruling class were separate, in Egypt, unlike all of the others, they were the same. So that the pharaoh, the boss, the emperor, was both the head of the ruling class, the supreme ruler of the area, but also the direct mouthpiece with the divine, with God. Now, similarly, the Japanese emperor is given divine authority to rule over the land. Now, another more familiar aspect may be this idea of hereditary authority. We, for example, live in a constitutional monarchy, an hereditary system, which actually has only recently changed. I'm not sure if you people here are all aware that the rules of succession have changed, I believe in 2013, only in the last few years, whereby before that time the British succession system was also used by Australia, so that the same person was always the monarch, and it was always the next male heir of that society. Now, there are still some societies in which an absolute monarchy does still exist. Brunei, for example, where the king is both an hereditary title and is also the absolute ruler of the society. So for us, though, the idea of the monarchy and the hereditary ruler is really more symbolic. It's really something that we can look at as an historic repository of power, but in contemporary times doesn't usually by custom exert any of that power. Now, there is other ways of acquiring power. Again, going back to sovereignty stories, in the 30s and 40s in Europe, the Nazi Party went about asserting sovereignty over a lot of its neighbours. This is acquiring power through force, and there are some theorists, myself included, that believe that fundamentally that is the source of all underlying sovereignty. In the case of Nazi Germany, we now don't consider it to be legitimate in terms of the claims it had over the neighbours that it conquered. But again, and this largely flows from my personal belief, I believe that that's largely because we won the war. In fact, if World War II had gone in a different way, then that sovereignty story would be used as the legitimate source of authority by, I guess, the ruling power. Now, another interesting sovereignty story to examine in a bit more depth in contemporary times is the South China Sea. Certainly, Chinese authority uses and justifies this position of, oh well, China has had and controlled this area since ancient times. It's even got a name on it. It's the South China Sea. Therefore, we're going to assert our historic claims to these islands by putting a whole bunch of sand and cement on them and creating air bases and such like. So another way of looking at sovereignty, and I guess another sovereignty story, is this idea of the will of the people. Now, returning back to Hobbes, it very much flows from his theorem that the people give legitimacy to the Parliament itself, which becomes the sovereign authority. We can't determine individually what and who should be the ruler, so we'll just cede our personal sovereignty to one larger entity. And as such, it has the legitimacy through just by saying, look, this represents the will of the people. That's not to say within society there aren't some, in fact maybe a lot of people who would gladly and happily replace our underlying parliamentary system with something alternate, something different. But in the words of Winston Churchill, that democracy is the worst form of government, except for every single other one that's ever been tried. So when thinking about internal and external sovereignty, I'm just going to draw your attention back to the Humane Society case. Now, there, as you'll recall, there were some Japanese whaling ships, and they had been operating in the Australian Antarctic Territory. Now, certainly the 200 nautical miles off the coast of Australia, the main part of Australia, the continent in Tasmania, that's not really in doubt here. What is in dispute to some extent is this border around the Australian Antarctic Territory. And the difficulty there is, of course, only about 4 other countries actually recognise Australia's claim to this particular territory, and as such, only those countries recognise this exclusive right for the Australian government, for the sovereign, to make laws over that particular area and exert their influence. So in regards to the underlying resolution of that case, creating some form of enforcement warrant or injunction for vessels, usually for some sort of federal agency, to arrest boats in there is quite problematic, because Japan doesn't recognise Australia's claim. Therefore, as far as they're concerned, any attempt by an Australian federal agency to arrest is really tantamount to some form of terrorism or piracy on essentially the high seas. And that's extremely problematic. And it's a good example, though, of these claims to sovereignty that entities have over different areas, and how the recognition of that sovereignty by third parties, by other nations, is very important in terms of determining how far the territorial limits and powers of each nation state actually extend. So then if we turn to the actual exercise of sovereignty, what does that actually mean? I mean, in a situation where, sure, we vest the king or the pharaoh, the emperor, whoever, with absolute power, what are the actual practical implications of that? I mean, surely the king or queen can't wave her or his sword around every single square metre of the entire society and govern directly. And so it's really all about how is power dispersed across this hierarchy. How do people get given power, and how do the underlying rules and laws go about governing that? And that's why when we hear this term governance, it's of great importance and something of really the something that contemporary research in this area is really focused on. It's not by coincidence, for example, that the unit that that our schools form part is now the College of Business Law and Governance. It's an important topic, and it's a bit of a slippery thing to come to grips with. So, for example, when we say that Parliament is the supreme lawmaking body, what does that really mean? In particular, what does it mean in relation to the other two arms of government, in terms of the courts and the executive arm? Well, really, it's about creating processes and using the tools of governance in order to both control and regulate all three arms. So when we think about governance, a formal definition is that it involves the institutions, the rules, the principles, the methods, the processes and the systems of decision making and the subsequent implementation of those decisions through which authority is vested. That's the really key part. We're giving authority to these various entities to go about and exercising that authority to do things, both inside our society and elsewhere. And while we think that may sort of mean government in the more general sense, it's a bit broader than even that. It's really to do with the underlying laws and rules that govern our society, and the government itself is really only a subset of that. And this is because while I guess at the institutional level, governance is the parliaments, the courts, government departments and police and ministries and so on, it also includes, and not just the positive law, legislation and case law, it also includes a lot of conventions and customs that we'll elaborate more later in this subject, and the processes, the participation of people in civil society, in juries, in vote making, in protesting. All of these things form part of the underlying process of governance. And so when thinking about governance and thinking about sovereignty, it may be helpful to just try and put our fingers on exactly where, if we could pick a single point in which legitimacy, in which the underlying sovereignty of Australia comes from, it can be very helpful to start with the Australian Constitution. It's a useful tool for looking at governance because it really forms, the underlying basis of legitimacy for all of our laws. Now, there are some complexities here. Obviously, the fact that the states predate the Federation of Australia, and that a lot of our laws are in fact state laws. They're not in relation to the Constitution. We'll talk about the structure of the Constitution later as well. But I think from drawing from the continental philosopher Hans Kelsen, Kelsen's almost scientific way of looking at the underlying legitimacy and validity of laws. In his theory, all laws come from a very, very basic norm that, in our particular case, that we ought to obey, in this case, the Australian Constitution. He uses the German term Grundnorm, the great norm. And so when looking at this, it may be helpful to, again, use a thought experiment when we're dealing with, say, a regulation. Say some form of environmental protection legislation. I'm not allowed to do some development on my land because it may upset the local ibis, for example. And we'll say that that's a regulation from at the federal level, so it's been done by the Commonwealth. Why is that valid from my perspective? Why is this norm something that I should obey? Well, working that chain backwards in time, the regulation is valid because it was expressed in a particular piece of legislation. Why is the legislation valid? Well, it was validly passed by the Australian Parliament and signed off by the Governor-General. Why is that piece of legislation valid? Well, because the Australian Constitution gives it that validity. And we could go even further back. Well, why is the Constitution valid? Well, because an equivalent United Kingdom Act of Parliament says the Australian Constitution is valid. Well, okay, why is the UK Act Why is the British Act of Parliament valid? Well, we can trace that back, perhaps, all the way back to the Battle of Hastings in 1066. And again, this comes back to this whole might is right. Why is all legislation passed by the British Parliament after that time valid? Well, because the king conquered the land. In essence, it flows, when you take it all the way back to it, to a might is right scenario. The underlying ground norm is that the UK Parliament has its legitimacy because William the Conqueror won the Battle of Hastings. So this brings me to another very important concept that we need to learn in this subject and is critical for your future legal education, called the rule of law. Now, in a single sentence, the rule of law can be expressed that each is equal before the law, including the executive arm of government. It really is that idea that no arm of government is above the law itself. And we contrast it to the phrase the rule of man, where, going back, for example, to 1066, William the Conqueror was the supreme authority. There were no checks and balances. There was nothing to stop William himself from doing whatever he liked. And we use that phrase, the arbitrary power of the sovereign. And the rule of law exists really to curtail that. And there's more things that sort of flow from that. Firstly, that there is a presumption of innocence, that the law must be readily known and available, it must be certainly clear, and that aspect it draws from this idea of the codification of the laws, the project of Jeremy Bentham. The law applies equally to everyone, it doesn't discriminate, so that some people can't be more equal before the law than others. There has to be some form of access to justice, some sort of independent legal advice. All of these concepts, they flow from that high-level principle that each is equal before the law. That the judiciary is independent and separate from both the executive and the legislature, the other two arms of government. That no person should be suffered to arbitrary punishment. And really that word arbitrary is the key part. That the executive arm of government cannot go and arbitrarily imprison people without trial, without being able to have them brought before the courts, another arm of government which can determine the underlying status of rights. And that the state themselves, and by state I mean the nation state, has to also comply with international obligations. And that's a really interesting one, and again subject to a lot of debate and criticism. And I really must say that this idea of the rule of law is very, very important. It's a very useful thing to learn now. It may be a little bit hazy at this stage in your legal education, but the processes that you'll learn, particularly in areas of public law, such as administrative law, when you learn about judicial review and merits review, in that this operates to create checks and balances on our systems. And having these checks and balances is really an important mechanism to maintain the underlying legitimacy of the crown, of the state itself. We as citizens accept the legitimacy of the sovereign because all of these checks and balances, these tools exist, and the government itself is also accountable to the law. So at this stage anyhow, it's suggested that you just tuck this away in your mind. The rule of law is that each is equal before the law. And it's helpful to just add an extra part in brackets, including the executive arm of government. That's fundamentally what this particular concept is about. So I'll turn now to Australia's own sovereignty story. And as previously mentioned, it really begins in the year 1066 when William I conquered the indigenous English people and defeated them at the Battle of Hastings. Now it's important to note at this point that William wasn't wanted. There was no popular idea of popular sovereignty. He spoke none of the indigenous languages. He had conquered and killed the popular indigenous king, and he took essentially control of the land through force of arms. So, at this initial stage, there is no separation of powers. In fact, one of the French kings had a great, very short line that said, in his demonstration of absolute power, "I am the state." In other words, all of the power, the sovereign power, is vested in me, and I shall choose how and where that power is exerted. I guess, in its simplest sense, what that means is that there is no legislative and judicial power. It's all arbitrarily applied and executed by the king. There is only the executive arm of government in that situation. Now, one of the problems of being the king, of course, is that you can't be everywhere at once. And so William went about doing some delegation. And I guess the most important way of delegating was to allocate parcels of land to his mates, to use and control, provided they owed fealty back to him. Now, this process of chopping the land up and having essentially a hierarchy, because each of the barons couldn't really realistically control each of the parcels of land themselves. They had to chop it up again and bestow smaller packets of land to local lords. And this process of having, a social pyramid with the king at the top, then barons, then local earls and knights, is the process of subfeudination. And really that's where the term the feudal system comes from. And so each person below another in that pyramid owes direct loyalty to those above, with the king at the top. All forms of tariffs and taxes flow upwards towards the king. Now, another thing the king became responsible for is exerting his own laws. One of the trouble of governing an area like England, which I guess in the modern sense doesn't sound like a very large place, but there were lots of little individual provinces, and each of the individual areas would govern themselves in their own ways. And so they would have judges and magistrates that would apply usually some form of customary law in a bit of an ad hoc, arbitrary sense. And William, now that he was the king of the land, wanted the judges to apply the law his way. He's the king. He wants the laws done and made the same across all of the lands of Britain. Now, this idea of trying to make the law the same, or make it common across the entire land, is actually where we get the basis of this term, the common law. It was all about William and his descendants trying to make his law the universal law of the land. Over time, however, the actual judiciary itself started to have and become its own source of power, and that it was the only arm of government that the king couldn't necessarily directly go and apply his arbitrary discretion about controlling individual things. Why? Because it got so complex. Part of what we refer to as the unwritten law is the idea that judges make law and they use precedents and cases from previous judges in order to make that. And so it develops over time and it becomes significantly more complex. And as noted on the slide, this transformation starts to move it away from it being the arbitrary discretion of the king to determine cases, or to send his own mates as judges around to determine cases, to the judiciary becoming its own institution. That's a very important thing, but it did take a very long time. And so in particular, this idea of judges following previously decided cases, the doctrine of precedence and the principle of stare decisis, separates the idea of having the arbitrary rule of the king, the rule of man, and pushes the system towards the idea of it being under the guise, at least, of the rule of law, that people and citizens become accountable to the laws themselves and not directly back to the king. So when looking at the legal system, and particularly in the early days, after 1066 and William conquering the land and sending his mates around to tell people what the law was, what happens when things go wrong? For example, what happens if two parties come to the court with two title deeds for the same piece of land, and both of which look legitimate, both have been signed and appear to have the appropriate information in it? How do the courts determine these situations, what to do? And so to, I guess, remedy any of these defects that the common law system had, there was always a parallel system that ran alongside the courts, known as equity. Equity was what's known as a court of conscience. And equity is an area, certainly throughout your legal education in common law nations, in Australia, New Zealand, the UK, the US, Canada, and so on, you will learn about. It's quite unique to the system, though, because it was an area that was designed to remedy defects and continues to do so, even in situations when from time to time something falls through the gaps, something a parliamentary lawmaker doesn't think about, or the rules of common law create a very harsh situation. They create a grave injustice. That was why these courts of equity, or chancery as they were known, were largely staffed by priests. They were appointed by the king, and the entire point of the courts of chancery was to provide a remedy in conscience when the common law could not. It's often said, in fact, that equity serves to mitigate the underlying harshness of common law rules. And it's also interesting to note here that equity itself developed, and it developed as an institutional response to the idea of adapting and moving with the underlying changes in the common law. Even today, we use the principles of equity to determine several aspects of the law that you'll study in more depth. For example, the doctrine of specific performance. When two parties to a contract, usually for the transfer of something unique or valuable, come into conflict, in other words, the contracting party doesn't want to give over the valuable thing, which incidentally includes packets of land, the other party can be compelled under these principles of equity to actually complete that particular contract. Now, equity has its own rules and its own principles, but they're largely guided by principles of conscience. In other words, they flowed originally from 800 years ago from the Christian beliefs and principles about what was fair and what was just. And it's interesting to note, again at this stage in your legal education, this ability for the law to adapt and to change, that rather than being a universal, a constant thing, it molds itself and adapts as society changes. Now, this system worked fine for the first 150 years or so, and by fine, I mean it would have been awful for 99% of the population, wonderful for the 1%. But nonetheless, the system operated, particularly when you had a very competent monarch. However, as in all systems of where titles pass through hereditary means, from time to time you'll get bad kings. And so, in the year 1215, they had a particularly bad king, and a group of barons got together and essentially shirt-fronted him. They quite bravely grabbed the king and made him sign a document. And this document, which is the Great Charter, or the Magna Carta, in the year 1215, is basically the first constitutional document of the UK. And most importantly, it states in the Magna Carta that from that point forward, the king cannot arbitrarily detain citizens. The king cannot delay or deny justice or trial again, I use the term citizen. That term actually doesn't arise for another 500 or 600 years. Essentially, as is the case with a lot of these documents, when it's referring to free men, it means free men in the very literal sense. It only applies to men who were really in the nobility in this case. And so with all of these constitutional texts, you just have to take some of these things with a little bit of a grain of salt. But the most important principle to come from that, from the Magna Carta, is that the law is now going to apply to all of the subjects, including the king himself. It's really the starting point of trying to curtail or remove the absolute power of the monarch to do anything that he or she likes. And now there are a series of constitutional documents, the Bill of Rights, the Act of Settlement, that apply to us in contemporary Australia. But if we had to pick a starting point for these documents, the Magna Carta has both historic and political significance. And in fact, from time to time, still gets used as a source of law, even in this day and age. So in this recording, we were introduced to a few of the key concepts that we really need to know about in order to continue with this subject. The idea of authority, both in its apparent and also in the underlying legitimacy behind that authority. We looked at the validity of laws, and we looked at sovereignty. And not only sovereignty within the state, in other words, the citizen in relation to the state, and the legitimacy that particular state may have there, but also between the states. And in particular, we talked about the Westphalian model, the idea that the nation state is the highest form of government, and other states, even if they don't like each other, still respect each other's existence. We discussed governance, and in particular talked about the idea of having a constitution as the fundamental document. We use the term Grundnorm from Hans Kelsen. We also talked about this concept of the rule of law, and this one we'll keep coming back to several times. It's an important tool of governance and a very important mechanism for those continuing with their legal education. We also talked about the basis of sovereignty in the form of sovereignty stories. We talked a little bit about the Australian sovereignty story and the role of the executive and the courts in that system. We talked a little bit about the history in order to get to the point where we're at, looking at the fundamental Grundnorm of our legal system, which arguably traces back to the Norman conquest. And then we briefly looked at the court system, and in particular the role of equity as something that can evolve and change with the law and in response to it, in its efforts to remedy the underlying harshness of common law rules.